The Republic of Trinidad and Tobago. The Republic of Trinidad and Tobago in the High Court of Justice claim no. CV 2020-04289 between Captain Gary Griffith claimant and Denise Wren. First defendant Ricky Ramdas. Second defendant Trinidad Express Newspaper Limited. Third defendant before the Honorable Madam Justice Jacqueline Wilson. Date of delivery, May 17, 2023. Appearances, Mr. Larry Lala instructed by Mr. Vashis C. Persad attorneys at law for the claimant Mr. Fairs Hossein instructed by Ms. G. Sampson attorneys at law for the first, second, and third defendant. Judgment 1. The claimant is the former Commissioner of Police. He alleges that 3 articles published by the defendants on 25 and October 26, 2020 relating to grant of firearm users licenses, fulls and/or licenses, by him are defamatory. The articles stated, in summary, that the claimant, I, knowingly issued licenses to persons against whom criminal charges were pending, 2, granted licenses to businessmen whose spouses had made reports of domestic abuse, and 3, expedited the grant of licenses to 1. Donors of the I Support Our Service Fund, an initiative launched by the claimant and his wife. 2. The claimant contends that the articles make serious allegations of professional impropriety against him with no evidence to support them, and that the defendants intentionally or recklessly brought his good name and performance as Commissioner of Police into disrepute. The defendants invoke the Defence of Reynolds Privilege with respect to the 3 articles and the Defence of Reportage in relation to the third. 3. At the time the articles were published, the first and second defendants were journalists employed by the third defendant, who is the printer and publisher of the Daily Express and the Sunday Express newspapers. 4. The questions that arise for determination are, a. Whether the articles are defamatory of the claimant, and if so, b. Whether the Defence of Reynolds Privilege and Reportage are established on the evidence. The Firearms Act 5. As stated earlier, the articles concern the exercise of the Commissioner's power to grant licenses under the Firearms Act. Under the Act, a person who wishes to obtain a firearm user's license must first apply to the Commissioner for the grant of a provisional license. An application for a provisional license must be supported by a certificate of good character issued by the Commissioner not less than 3 months prior to the date of application. A provisional license is valid for 2 months and allows the holder to discharge a firearm for training purposes at a designated shooting range under the supervision of a person who holds a firearm user's license. 2.6. Upon the expiration of a provisional license, a person may apply to the Commissioner for the grant of a firearm user's license. The application must be supported by a certificate of competence issued by a licensed firearms instructor. A firearm user's license is valid for 3 years and may be renewed upon payment of the prescribed fee. Its terms and conditions may, from time to time, be varied by the Commissioner. 7. The Commissioner may grant a firearm user's license where he is satisfied that an applicant has good reason to acquire and possess a firearm and ammunition without posing a danger to public safety or peace. A license may not be granted to a person whom the Commissioner has reason to believe is of intemperate habits or unsound mind or is otherwise unfit to be entrusted with a firearm or ammunition. Where a person is convicted of a domestic violence offense under the Domestic Violence Act, the Commissioner may refuse to grant the person a firearm user's license for a period of 5 years from the date of conviction. 8. The Commissioner may revoke a license where he is satisfied that the holder is of intemperate habits or of unsound mind, or is otherwise unfit to be entrusted with a firearm or ammunition. Where a license holder is convicted of an offense under the Domestic Violence Act, the Commissioner may suspend the license for a period of 5 years from the date of conviction. The first Article 9. The first article was written by the first defendant and published in the Sunday Express newspaper of October 25, 2020 under a front-page headline that read, "Gun Scandal, People on Illegal Firearm Charges Granted Users Licenses." Next to the headline was a photograph of the claimant in uniform, holding a firearm. The full article was published on page 3, under the heading Sunday Express Probe Uncovers, People on Gun Charges Getting Firearm Licenses. It read as follows. 3 individuals charged with firearm-related offenses such as possession of illegal arms and ammunition have been granted licenses for legal firearms. All firearm users' licenses, fulls, are signed off on by the Police Commissioner Gary Griffith. An 11-month Sunday Express investigation has revealed these licenses have been granted despite recommendations against them from officers tasked with probing whether individuals fit the criteria to have a provisional license, PL, or firearm user's license. Several people who are now holders of legal licenses are under active police investigation and currently before the court charged with criminal offenses. A PL authorizes the holder to discharge a firearm at a specific shooting range for the purpose of training in the use of the firearm. It expires 2 months from the date of issue, following which the holder can apply for a full. A full authorizes its holder to be in legal possession of a registered firearm and ammunition. The Sunday Express also uncovered instances where applicants were issued PLS and fulls but did not have the prerequisites such as a certificate of good character which is issued by the T&T Police Service. One such instance uncovered during the Sunday Express investigation showed that on November 4, 2019, a recommendation attached to a file was dispatched by the Superintendent of the Southwestern Division regarding a 52-year-old businessman. For the recommendation stated, Commissioner of Police, the applicant is currently under investigation by the Financial Intelligence Unit and the Southwestern Division Gang Unit. He was also arrested for trafficking marijuana and cocaine in a Caribbean island. The applicant is not recommended. The businessman in question made an application for a PL on August 10, 2019. He was approved for the PL by Gary Griffith on September 4, 2020, to use a revolver pistol and shotgun. Checks by the Sunday Express revealed that the businessman is currently before the court on matters which include 1. May 15, 2019, larceny, 2. November 8, 2019, possession of ammunition 3. November 8, 2019, possession of a prohibited animal. The businessman was also arrested in Venezuela in connection with cocaine trafficking. He was subsequently released. The Sunday Express understands it's not sick practice where a file which carries not recommended is overturned by the Commissioner given the reasons why the application is not recommended. Abusive husbands. Additionally, in 5 separate instances, reports were made to police stations within the Western Central and Southern Divisions by spouses of businessmen who alleged they were physically assaulted and threatened by their husbands in 2017 and 2018. All 5 businessmen were granted fulls in 2019. The Sunday Express investigation revealed several business owners had their full applications fast equals tracked, sick, and these businessmen are also donors which have 5 signed on to the I Support Our Service, ISOS, initiative of Griffith and his life, sick, Nicole, which was launched last year. It involves businesses pledging support such as discounted prices for police officers or providing tangible items to the TTPS. Flashback. At a weekly police news conference on June 2, 2019, SGT David Swanson of the TTPS Firearms Section said Griffith had seen it fit to take the lead to address the challenges faced by the Firearms Section by utilizing a hands-on approach to efficiently and effectively deal with all applications, both current and pending. Swanson said then that people who submitted applications between 2004 and 2010 needed to provide the unit with up-to-date documentation, including certificates of good character, psychometric evaluations, change of address and passport-sized photographs. He further explained people with pending applications made before 2004 would have had to reapply as the application forms had been altered in that year. Swanson had indicated in order to fast-track the investigation and approval of applicants, Griffith had provided additional staff and resources to the unit. In addition to the amendments to the application process, Griffith also increased the limit of the ammunition that can be held by a license holder from 25 rounds to 40 rounds. The authority lies solely with the Commissioner of Police, and it must be clearly stated that there is not a cost attached to the application for and the granting of a firearm user license with exception to the annual license fee, Swanson had said. 6 On December 19, 2019, Griffith, via a news release, advised against paying anyone, including police officers, to secure a full, warning this will not assist in fast-tracking the application. Griffith said he has been made aware that numerous people have claimed to know certain senior police officers who had promised to assist them in securing their fulls. There are those who have been claiming to have good links with senior officers. The Firearms Section and the Office of Commissioner of Police adhere to a strict process for approving and issuing fulls, the release noted. The TTPS stated approximately 423 applications were approved for the period August 2017 to July 2018. Between August 2018 and December 19, 2019, 1,887 full applications were approved. 10. In his statement of case, the claimant asserts that the ordinary and reasonable reader reading the first article would understand it to mean that, the claimant is responsible for a scandal where the claimant, a. has granted multiple individuals charged with firearm-related offenses licenses to allow their possession of legal firearms. Has granted multiple individuals licenses to allow their possession of legal firearms despite the recommendations of the relevant police investigations. C. Is responsible for there being multiple holders of firearms licenses who are now under active police investigation or who are currently before the courts charged with criminal offenses. D. Is responsible for multiple persons being issued firearm licenses where they did not possess the required police certificate of good character. 7. Acted improperly and inconsistently with the responsibilities of his office when he granted a provisional license against the recommendations of the Superintendent of the Southwestern Division to a 53-year-old businessman with full knowledge that the individual was arrested for drug trafficking and currently under serious criminal investigation. F. In issuing the provisional license, the claimant ignored the advice given to the claimant by the Superintendent of the Southwestern Division. G. In 5 instances acted improperly and/or contrary to law when he gave firearm users licenses to businessmen against whom reports had been made of physical assault and threats to their wives. H. Had improperly/unlawfully or corruptly fast-tracked or caused to be fast-tracked the full applications of several business owners because the business owners were donors to the ISOS initiative by the claimant and his wife. I. Was guilty of hypocrisy since his stated policy in June 2019 was that there was to be no favoritism or corruption involved in the granted of firearms users' licenses. 11. The defendants state in their defense that the first article was published on an occasion of qualified privilege. They assert that the grant of licenses by the claimant was a matter of serious public interest and concern and that the first article was published after 11 months of investigation by the first defendant. Before its publication, the first defendant sent 3 questions to the claimant and his response was given full prominence in the article. The first defendant's questions and the claimant's response were published under the heading, Griffith, I met a flawed investigative process and are set out in full below. I. Did investigating officers advise you against the issuance of fulls and provisional licenses to several citizens, and did you ignore that advice? If yes, why? 8. Upon my assumption to the Office of Commissioner of Police, I inherited a backlog of pending full applications where persons would have gone through the investigative process and met the criteria for the issuance of an full, but were left in a land of abeyance with no word as to whether or not their applications were approved. I met several letters from attorneys making representation on behalf of their clients threatening legal action and several pending firearms appeal board matters. I sought to clear up the backlog. In so doing, I met a flawed investigative process which I'm in the process of correcting. Additionally, with regards to the non-recommended files by investigators, I found it to be subjective and unfair. Just because persons' lives were under no immediate threat, they were not recommended. Am I to wait until there is an attempt on the life of a citizen before I can give them the opportunity to defend themselves, their families and their property? Not under my watch. As such, I took the decision to review all these files and used my authority given to me by the Firearms Act to grant such licenses. As Commissioner of Police, I am going to do everything within my lawful power to protect the lives of the citizens of this country. I issued fulls to persons of all walks of life without fear or favor, malice, or ill will. Firearm users licenses August to December 2018, 613 January to December 2019, 1695 January to September 2020, 1628 Provisional permits August to December 2018, 213 January to December 2019, 946 January to September 2020, 1083. 9 Prior to taking up office, the figure for fulls for 2018 was 126, and provisionals was 19. 2. Why did you approve fulls and provisional licenses to several applicants who are currently before the courts on criminal charges? Again, due to a flawed investigative process that I inherited and am in the process of restructuring. I understand that before my tenure persons with pending charges were granted fulls. I have since formed an intelligence and investigative unit within the firearms section called the Firearms Compliance Unit that reports directly to me on all issues of non-compliance with regards to persons attempting to slip through the cracks. I have also instructed that the criminal records which include pending matters to be placed on full applications to properly guide me in my deliberations. Investigators have a period of 2 months to complete their investigations, as instructed by the standing orders. If they fail to do so, I am going to exercise the power to intervene by way of Firearms Compliance Unit to run proper background checks on all applicants. 3. Several businessmen who were granted fulls are also donors to ISOS, I Support Our Service, Fund. Were you influenced by this? Your character may allow you to be influenced by donations. Mine is different. Such an irresponsible comment is expected by the Express. It is similar as asking if the Express would be biased and influenced to print false or biased stories to benefit those who advertise in their newspaper. Is this what the Express does? Are they influenced by external units to discredit the police? 10. Unlike the Express, the TTPS is not influenced by those who are mature enough to decide to work with the TTPS to reduce crime. And fulls are approved based on persons having the right to bear arms if they provide what it required. Whilst certain persons do just the opposite, as it seems that they have a directive and an agenda to discredit the TTPS, as every article they print, it is aligned to attack the police. Are you being influenced by external persons to publish 44 consecutive negative articles on the TTPS? 12. The defendants assert that the first defendant was satisfied that the information in the first article was reliable, having originated from a confidential source within the police service. They contend that by virtue of the claimant's position as commissioner, his legal responsibility for the grant of licenses and the information received by the first defendant in the course of investigations, the first article reported on matters of public interest and concern. They contend that the defendants had a duty to publish the first article and the public had a legitimate interest in receiving the information. The second article 13. The second article was also written by the first defendant and published on October 26, 2020 in the Trinidad Express. It followed the publication of a media release the day before by the Corporate Communications Unit of the Trinidad and Tobago Police Service, TTPS, in response to the first article. The TTPS media release bore the heading, "There is no gun scandal." It strongly criticized the first article as providing false and misleading information and challenged the defendants to name the persons to whom licenses were granted unlawfully. 14. The second article was published under a front-page headline that read, Here's the proof. Express responds to Griffith's denial that no accused granted legal. 11 firearms. Also featured on the front page was a photograph of the claimant and of 3 documents bearing the TTPS stamp, redacted to conceal the name of the signatory. The second article was published in full on page 3 under a headline that read, "We have proof, Gary." It repeated many of the statements in the first article and stated as follows. Here's the proof the police commissioner has asked for. In a media release yesterday, top cop Gary Griffith stated categorically that he never approved provisional licenses, PL, and firearm users licenses, full, to individuals before the courts charged with criminal offenses and individuals who are also under current police investigation. This denial contradicts documents in the express possession, however. An 11-month investigation published in yesterday's Sunday Express revealed despite strong recommendations from officers tasked with probing whether individuals fitted the criteria to have a PL and fulls, Griffith ignored advice and affixed his signature approving licenses to persons under active police investigation and currently before the courts charged with criminal offenses. Additionally, the Sunday Express investigation, which is supported by documents bearing Griffith's signature and the TTPS official stamp, also uncovered instances where applicants did not have the prerequisites such as police certificate of character which is issued by the T&T Police Service but were issued PL and full. One such instance reported by the Sunday Express showed that on November 4, 2019, a recommendation attached to a file was dispatched by the superintendent of the Southwestern Division regarding a 53-year-old businessman who is currently under police investigation for marijuana and cocaine trafficking and money laundering. The businessman is currently before the courts charged with the following offenses: 1. May 15, 2010 larceny, 2. November 8, 2019 possession of ammunition, 3. November 8, 2019 unlawful possession of ammunition. 12-4, November 8, 2019 possession of a prohibited animal. He was also arrested in Venezuela in connection with cocaine trafficking and subsequently released. The application's documents in the express possession on this case revealed that the businessman has been granted a provisional license to discharge a revolver, shotgun, pistol. This was signed off by Griffith on September 4, 2020, despite a recommendation from the Senior Superintendent, Southwestern Division, on November 4, 2019 that the businessman not be granted a PL. The recommendation stated, "Commissioners, SIC, of Police, the applicant is currently under investigation by the Financial Intelligence Unit and the Southwestern Division Gang Unit. He was also arrested for trafficking marijuana and cocaine in a Caribbean island. The application is not recommended." The businessman in question made an application for in full on August 10, 2019. Additionally, in a letter dated October 16, 2019, his 35-year-old Venezuelan wife stated she was aware her husband of 2 months, at the time of application, has applied for a firearm and I have no objections in him obtaining a firearm as it would be for our protection. The typed one-page letter was signed by an acting corporal and dated October 16, 2019. In 5 other separate instances, reports were made to police stations within the Western, Central, and Southern divisions by spouses of businessmen who alleged they were physically assaulted and threatened by their husbands in 2017 and 2018. All 5 businessmen were granted fulls in 2019, which were signed off by Griffith. The Sunday Express investigation also revealed that several business owners had their full applications fast-tracked and these businesses are also donors who have signed on to the I Support Our Service, ISOS, initiative of the TTPS. 13. The ISOS, which was launched last year, is the brainchild of Griffith and his wife Nicole. It involves businesses pledging support for the TTPS such as giving police officers price discounts on items to the TTPS. 15. The claimant asserts that the second article is defamatory for the same reasons that are advanced in respect of the first article. The defendants refute the assertion and contend that the second article was published on an occasion of qualified privilege and in response to the TTPS media release. They allege that the second article provided the proof sought by the claimant and that its publication was justified for the same reasons as the first article. The third article 16. The third article was written by the second defendant. It was published on October 26, 2020 under the headline, "Cop Denies Gun Scandal." It quoted extensively from the TTPS media release and the claimant's firm denial of the defendant's allegations. 17. The defendants contend that the third article was published on an occasion of qualified privilege and rely on the same assertions that were made in respect of the first and second articles. They state that the third article provided a neutral report of the first article and the press release without adopting or embellishing their contents or subscribing to their truth. Therefore, the third article was the product of responsible journalism and there was no requirement for second defendant to establish the truth of its statements. 14. The evidence 18. The claimant gave evidence in support of the claim. The first and second defendants and the editor-in-chief of the third defendant, M.S. Omadi Leiter, gave evidence on behalf of the defendants. 19. In his witness statement the claimant asserts that the allegations made in the articles are untrue. He states that in putting questions to him, the third defendant failed to inform him of the names of the persons to whom he had improperly granted licenses and that he would have set the record straight had he been so informed. 20. The claimant states that the TTPS press release gave the true version of events. He explained that TTPS staff reviewed all applications for the grant of licenses before they were submitted to him for his approval and signature. As a result, he did not check each individual file. Where an application was approved, the compliance unit conducted comprehensive background checks and due diligence investigations with the Financial Investigation Unit, the Strategic Services Agency, the Special Investigations Unit and the Financial Investigations Bureau before submitting a license for his signature. 21. In cross-examination, the claimant stated that prior to his appointment as commissioner there were approximately 50,000 outstanding applications for the grant of licenses. He treated the backlog as a matter of priority and established the compliance unit to promote efficiency and prevent abuse. Where an application for a license was approved, the approval was sent to the full department for distribution of a license where authorization had been given by the compliance unit. There were instances where, after approval of an application and before issuing a license, concerns were raised by the There were instances where, after approval of an application and before issuing a license, concerns were raised by the compliance unit. In such cases, no license was issued to 15. An applicant. The claimant denied that, as a matter of practice, he approved the grant of licenses to persons with pending criminal charges. 22. The claimant stated further that, on 20 September 2020, he approved the grant of provisional licenses to a number of applicants but the licenses were not issued to them in light of the publication of the first article on that date. He stated that the TTPS media release acknowledged that in one case out of approximately 6,000, a license had been granted to an applicant who did not meet the requirements through administrative error. 23. In her witness statement, the first defendant states that, as an investigative journalist, she has acquired a network of sources who provide her with accurate and reliable information in confidence. She states that, after receiving the information published in the first and second articles from a confidential source, she sent 3 questions to the claimant for his response to the allegations that he had issued licenses to persons who did not meet the requirements. She states that the second article quoted directly from the documents provided by the confidential source and that she did not publish the documents as she received the information in strict confidence. 24. In cross-examination, the first defendant stated that she had reviewed at least 15 files in which persons on firearm-related charges had been granted licenses. That she recorded the names, dates of birth and file numbers of the persons, that she obtained copies of their criminal records, and that she took steps to confirm their convictions at the TTPS Criminal Records Office and various magistrates' courts. As regards the businessmen whose spouses were alleged to have made reports of domestic violence, the first defendant stated that she had seen the police reports and had obtained copies of the licenses that were granted. She stated further that she had obtained the names of the businessmen whose applications had been expedited, the 16 dates on which their applications were made, the dates on which the applications were approved, and the variations that were made to their licenses. She stated that in many cases the applications were approved within hours of submission. 25. The first defendant refused to disclose the names of the persons whose files she had reviewed, citing security reasons and the need to protect the source of her information. 26. In her witness statement, Ms. Omadi Lider states that she was satisfied that the first defendant obtained the information published in the articles from credible and trusted sources and that the documents she had reviewed were authentic. She states that, as editor of the third defendant, she considered the articles to be of serious public interest and concern and that it was wholly justifiable to publish them. 27. In cross-examination, Ms. Lider stated that the first defendant had provided her with the names of 10 persons whose files had been reviewed. She refused to disclose the names of the persons for the same security reasons given by the first defendant. Whether articles defamatory. 28. In determining whether a publication is defamatory, a court must consider the natural and ordinary meaning, including any inferential meaning that the words convey to the mind of the ordinary, reasonable, and fair-minded reader. 29. In Civ App No. 118 of 2008 Khayyam Mohammed and others v Trinidad Publishing Co. Ltd. at paras 11-14, Mendonca J.A. discussed the approach to be taken by a court. 11. The court should therefore give the article the natural and ordinary meaning the words complained of would have conveyed to the notional. 17. Ordinary reasonable reader, possessing the traits as mentioned by Lord Nichols, in, and reading the article once. The natural and ordinary meaning refers not only to the literal meaning of the words but also to any implication or inference that the ordinary reasonable reader would draw from the words. Thus in Lewis v. Daily Telegraph 1964 AC 234, 258 Lord Reed stated, "What the ordinary man would infer without special knowledge is generally called the natural and ordinary meaning of the words." But that expression is rather misleading in that it conceals the fact that there are two elements in it. Sometimes it is not necessary to go beyond the words themselves, as where the plaintiff has been called a thief or a murderer. But more often the sting is not so much in the words themselves as in what the ordinary man will infer from them, and that is also regarded as part of the natural and ordinary meaning. 12. And Lord Morris in Jones v. Skelton. 1963. 1 WLR 1363. 1370-1371 stated, "The ordinary and natural meaning of words may be either the literal meaning or it may be implied or inferred or an indirect meaning. Any meaning that does not require the support of extrinsic facts passing beyond the general knowledge but is a meaning which is capable of being detected in the language used can be part of the ordinary and natural meaning of words. The ordinary and natural meaning may therefore include any implication or inference which a reasonable reader, guided not by any special but only by general knowledge and not filtered by any strict legal rules of construction, would draw from the words." 13. 14. Where, as in this jurisdiction, the judge sits without a jury, it is his function to find the one correct meaning of the words. Although when considering 18. The defense of Reynolds privilege, the court must have regard to the range of meanings the words are capable of bearing, as I will mention below. It is still the function of the judge as regards the meaning of the words complained of to find the single meaning that they do convey. That does not mean that where an article levels a number of allegations, as is the case here, that it has only one meaning. What it does mean is that where there are possible contradictory meanings of the words, the court cannot recognize, what may be the reality, that some reasonable readers will construe the words one way and others another way. The court must determine the one correct meaning out of all the possible conflicting or contradictory interpretations. 30. Counsel for the defendants relies on the decision of Lord Bridge of Harwich in Charleston v. News Group Newspapers Ltd. 1995. 2 AC 65. A case in which the photographs of certain actors were superimposed on the bodies of other persons, where it was stated that in order to determine the natural and ordinary meaning of words it was necessary to consider the context in which the words were used, their mode of publication and the relative prominence given to different parts of the publication. A claimant could not complain of an isolated passage in an article if other parts of the same article threw a different light on that passage. It was also necessary to consider whether any conclusions made in the article were sufficient to neutralize statements that may otherwise be perceived as disreputable to a claimant. 31. Counsel for the defendants argues that the ordinary reasonable reader would not have concluded that the first article bore the meaning contended by the claimant and would have understood the article to mean that, upon his appointment as commissioner, the claimant had inherited a deficient system for the grant of licenses, that he took steps to remedy the deficiencies, and that the investigations of the first defendant identified irregularities which required the claimant's explanation. 1932. In the Privy Council decision of Ramadar v. Ramadar, 2020 UKPC 7, Lady Arden provided guidance on finding the meaning of words, citing the list of essential criteria stated by Sir Anthony Clark MR in Janes v. News Magazines Ltd 2008 EWCA Civ 130 at 14 and approved by Lord Kerr in Stocker v. Stocker 2019 UKSC 17 at Para. 35. 1. The governing principle is reasonableness. 2. The hypothetical reasonable reader is not naive, but he is not unduly suspicious. He can read between the lines. He can read in an implication more readily than a lawyer and may indulge in a certain amount of loose thinking. But he must be treated as being a man who is not avid for scandal and someone who does not, and should not, select one bad meaning where other non-defamatory meanings are available. 3. Over-elaborate analysis is best avoided. 4. The intention of the publisher is irrelevant. 5. The article must be read as a whole, and any bane and antidote taken together. 6. The hypothetical reader is taken to be representative of those who would read the publication in question. 7. In delimiting the range of permissible defamatory meanings, the court should rule out any meaning which can only emerge as the produce of some strained, or forced, or utterly unreasonable interpretation. See EDJ in Gillick v. Brooke Advisory Centers approved by this court 2001 EWCA Civ 1263 at 7 and Gadley on Libel and Slander 10th ed., Para 30.6. 8. It follows that it is not enough to say that by some person or another the words might be understood in a defamatory sense. Neville v. Fine Art and General Insurance Co. Ltd 1897 AC 68. 73, per Lord Halsbury LC. 33. I have concluded that the natural and ordinary meaning of the words used in the first article, considered as a whole and in their true context, is the meaning for which the claimant contends in his statement of case. That is to say, that the articles would be understood to mean that the claimant has granted licenses to persons who did not meet the requirements and that, in so doing, he abused his authority and brought the office of commissioner into disrepute. The first article is therefore defamatory. To the extent that the second and third articles repeat the statements made in the first article, they too are defamatory. Whether Reynolds Privilege established 34. The question that arises is whether the defense of Reynolds Privilege should succeed. 35. In Jamil v. Wall Street Journal Europe, 2006. UKHL 44 at Para 146 Baroness Hale of Richmond described the objective of the defense in the following terms. The defense of Reynolds Privilege springs from the general obligation of the press, media, and other publishers to communicate important information upon matters of general public interest and the general right of the public to receive such information. The Reynolds public interest defense is designed to strike an appropriate balance between freedom of expression, freedom of the press, and the right of the public to know on the one hand and the protection of a person's reputation on the other. 36. In the Court of Appeal decision of Guardian Media Limited v. Ushvin Creed, Civil Appeal No. P022 of 2017, at paras 32-38, Mendonca J.A. cited the guidance provided in Khayyam Mohammed and others v. Trinidad Publishing Company Limited and others Civil Appeal No. 118 of 2008 on Reynolds Privilege, 32. In Khayyam Mohammed and others v. Trinidad Publishing Company Limited and others Civil Appeal No. 118 of 2008, this court stated in relation to Reynolds Privilege, at paras 59 and 60-59. Reynolds Privilege derives its name from the well-known case of Reynolds v. Times Newspapers Ltd., sub 2002 2 AC. 127. It is built on the traditional 21 foundation of qualified privilege, which requires a mutual duty and interest between the publisher and recipient of the information. It is accepted that in a modern democracy the journalist has a professional duty to impart information on matters of public interest and the public has an interest to receive such information. The defense therefore applies in the case of a publication by the press, which is the case here, but it can also apply to other publications. See Sega v. Harper 2008 3 WLR 478. 60. The defense of Reynolds Privilege is a complete defense and if established denies any remedy to the claimant. It only arises as a live issue where the statement in question is defamatory and untrue. Reynolds Privilege therefore protects the publication of untrue and defamatory matter. It does so for two reasons that impact on freedom of expression and freedom of the press. First, so as not to deter the publication in question, which might have been true, and secondly, so as not to deter future publication of truthful information. See Lauchinsky v. Times Newspapers Ltd. No. 2, 2002 1 All ER. 652,68, at para 41. It protects such matters where the publication is to the public at large or a section of it and where 1. It was in the public interest that the information should be published and 2. Where the publisher has acted responsibly, a test usually referred to as responsible journalism. There are therefore two key questions which must both be answered in the affirmative before a court can hold that a publication is protected by the defense of Reynolds Privilege. The first is whether the subject matter of the publication was a matter of public interest. 33. In determining whether the subject matter of the publication was a matter of public interest, consideration should be given to the publication, in this case the 22 articles, as a whole and not only to the defamatory statements within them. See para 48 of Jamil and another v. Wall Street Journal Europe SPRL 2006 UKHL 44. 35. In my view, in this appeal, in determining whether the articles were in the public interest, it would be appropriate to ask whether there was a real public interest in communicating and receiving the information contained in the articles. 36. If it is established that the publication was in the public interest, the next question that must be considered is whether the publication was the product of responsible journalism. As Lord Nichols said in Bonnick v. Morris and others 2003 1 AC 300 at para 23, 23 stated shortly, the Reynolds Privilege is